Welcome to the lesson on the FinTech challenge to property rights under English law. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. In 2020, the FinTech sector underwent an unprecedented expansion, permeating virtually every domain of business transactions. These developments encompassed, but were not limited to, technologies and practices such as artificial intelligence, blockchain, crowdfunding, cryptocurrencies, cybersecurity, decentralized autonomous organizations and decentralized finance, DAOs and DeFi, Internet of Things, non-fungible tokens, NFTs, payment systems, peer-to-peer debt and equity financing, RegTech, robo-advice and smart contracts, to name a few. The rapid rise of FinTech has also given rise to a new layer of legal challenges. One prominent example involves blockchain-based assets, especially cryptocurrencies, and the growing incidence of misappropriation by hackers. In the decision of Ruscoe and Cryptopia 2020, the New Zealand High Court held that the equitable doctrine of constructive trust was the appropriate vehicle for redress in such cases, on the condition that a valid trust exists, which in turn depends upon the presence of the three certainties: intention, subject matter and object, as mandated by the Trusts Act 2019. That judgment built upon the English High Court decision in AA and Persons Unknown 2019, which accepted that crypto assets, in that case Bitcoin, can be treated as property under English law. Comparable earlier judgments include Liam David Robertson and Persons Unknown 2019 and Vorotyntseva and Money 4 Limited 2018. These cases collectively opened the possibility for owners of crypto assets to avail themselves of proprietary remedies by virtue of a constructive trust. As noted by the UK Jurisdictional Task Force's Legal Statement on Crypto Assets and Smart Contracts 2019, there is no impediment in principle to treating crypto assets as property and smart contracts as legally binding. In Ruscoe, Judge Bryan held that crypto assets satisfy the criteria established in National Provincial Bank and Ainsworth 1965. Namely that they are 1. Definable, 2. Identifiable by third parties, 3. Capable in their nature of assumption by third parties, and 4. Have a degree of permanence. Turning to trust law, the most problematic of the three certainties is often the certainty of subject matter. Classical cases illustrate the difficulties. In London Wine, 1986, the trust failed for bottles of wine because the individual bottles could not be segregated. Judge Oliver observed, however, that a trust over a homogeneous mass may survive if the mass is identified as a whole. In Hunter and Moss, 1994, Lord Justice Dillon held that a trust of 50 shares out of 950 did not require individual identification because the shares were of the same type, thus creating a precedent for intangible subject matter. The fungibility or otherwise of the property becomes critical. Where the asset is non-fungible and unique, the subject matter may need to be segregated, leading to a London Wine-type failure. In contrast, Ruscoe adopted the fungible intangible asset approach, treating cryptocurrency as fungible and thereby satisfying the subject matter requirement. Given that subject matter is often the most contentious element, it follows that the rapid diffusion of FinTech into multiple spheres presents analogous trust law challenges. As technological-driven transactions proliferated, especially during the pandemic, which accelerated the shift from in-person to digital interaction, the hastened adoption of FinTech systems brings into sharp relief questions of asset identification, verification, and segregation in new contexts. This evolving landscape illustrates that while FinTech offers significant innovation and efficiency gains, it simultaneously generates complex legal questions about property rights, fiduciary relationships, and equitable obligations. Questions which demand rigorous analysis in postgraduate and professional settings alike. Werbeking argues that the unique technical architecture of smart contracts necessitates significantly greater formalization, standardization, and simplification than traditional offline contracts. For example, they struggle to accommodate inherently ambiguous clauses, such as those invoking good faith or equitable discretion. One strategy to ameliorate these constraints is the deployment of external data feeds, commonly known as oracles. which enables smart contracts to ingest real-world information, for instance, payment triggers or live market data, thereby linking automated execution to off-chain events. The simplification inherent in smart contract structure also means that ambiguity in contractual terms is reduced, potentially fewer misinterpretations of the parties' intentions. From the perspective of equity, this might suggest fewer opportunities for contention. However, the downside is that smart contracts are best suited to relatively straightforward transactions, and such simplicity renders them less appropriate for the more complex arrangements in which equitable concerns typically arise. Indeed, Herian argues that smart contracts currently lack the sophistication to deliver adequate remedies for breaches of promise. For a more nuanced examination of how equity might apply to smart contracts, consider the established trust law framework. A valid trust instrument must demonstrate the three certainties: intention, subject matter, and object. With smart contracts, the first question is whether the subject matter, i.e., the underlying asset or benefit, qualifies as property capable of being held on trust. Nicol argues that in the wake of Ruscoe and Cryptopia, it is necessary to show that the relevant asset qualifies as property and is capable of being held on trust. Outside the cryptocurrency context, smart contracts might execute transactions analogous to those in London Wine or Hunter and Moss, and indeed the doctrinal principles from those authorities could apply. The parties might therefore achieve reasonable certainty of subject matter when the asset is clearly described in an offline contract accompanying the code. But if the terms are expressed only in computer code, issues arise. Werbeking suggests that judges, who typically lack advanced technical literacy, may need expert assistance or be directed to alternative dispute resolution mechanisms. A more formidable issue is the risk of programming error. If the code contains a mistake that undermines one or more of the certainties, for example, by rendering the subject matter or intention unclear, then the trust may fail for want of certainty. This highlights a vulnerability. Smart contracts may be ill-suited to equitable remedies because their automated, immutable nature offers little room for the interpretive, discretionary intervention characteristic of equity. Of course, the risk of such error is mitigated if there is a conventional document underpinning the smart contract. Uneman and Milkow remark that in the absence of an offline document, and given the prevailing view that smart contracts are legally binding and that code is law, one may argue that any contract executed entirely in code is voidable from its inception. This approach, as suggested by some commentators, conflicts with the immutability principle of distributed ledger technology and may therefore be of limited practical utility. Notwithstanding these challenges, the foregoing discussion should not lead one to conclude that equitable principles have no application to FinTech contexts. On the contrary, as Flaczyk argues, equity may serve to counterbalance some of the undesirable risks introduced by emerging technologies, particularly those related to fairness, trust, and adaptability in transactions facilitated by smart contracts. Thank you for your interest in this topic. To learn more about digital finance, take a look at our dedicated videos. We hope that this lesson was helpful to you and are looking forward to seeing you again soon.